The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act, which has the purpose of making a state a two-way sanctuary state.
A revised version of the Second Amendment Preservation Act is moving through the Senate, but it's facing renewed opposition.
This case deals with a state's Second Amendment Preservation Act, also known as a SAPA law.
Supreme Court turns down Missouri's bid to revive a law that declares various federal gun restrictions unconstitutional.
It has already been approved by several Senate committees. However, as we saw on the Senate floor today, not everyone is on board.
8 justices just voted against Missouri's gun law. One justice stood completely alone. But buried in this ruling is a statement from 2 conservative justices that the media completely ignored, and it might have just handed gun rights supporters a secret weapon that could reshape Second Amendment enforcement across America. So, here's what everyone got wrong about this Supreme Court decision. The headlines screamed defeat. They said Missouri lost. They claimed the Second Amendment Preservation Act was dead in the water. But when you actually read what Justices Gorsuch and Alito wrote in their statement, you realize something extraordinary is happening beneath the surface. This isn't a simple loss. This is a legal chess move that could fundamentally change how states resist federal gun enforcement, and the implications stretch far beyond Missouri's borders. Let me break down exactly what happened, why Justice Thomas was the only one willing to publicly support Missouri, and most importantly, what this Gorsuch-Alito statement actually means for gun owners right now. Because what's really going on here is not what anyone is telling you. The Supreme Court just issued an 8-1 decision denying Missouri's emergency request to protect their Second Amendment Preservation Act. Justice Clarence Thomas stood as the lone vote supporting Missouri's stay application. Chief Justice Roberts joined 7 other justices in denying the state's protection. Now here's the first thing you need to understand about how this actually went down. This decision came through what's called an emergency application. That means Missouri never got a full hearing. No oral arguments, no extensive written briefs, no opportunity to fully present their case before the highest court in the land. They were essentially asking the Supreme Court to hit the pause button while their appeal worked its way through the system. Missouri filed this application after getting rejected twice. First, the district court said no. Then the 8th Circuit Court of Appeals said no. Both lower courts refused to pause the injunction against Missouri's law, which forced the state to take their last shot with the Supreme Court. But here's what makes this so fascinating. The court didn't actually rule on whether Missouri's law is constitutional. They didn't decide if the state was right or wrong on the merits. All they decided was whether to temporarily pause the lower court's injunction while the appeal continues, and they chose not to intervene, at least not yet. When 8 justices agree on something in an emergency context, it typically signals they want the lower courts to fully develop the record before the Supreme Court gets involved. They're essentially saying, let this play out a bit more before we step in. But there's a massive twist to this story that completely changes how we need to interpret this order, and it involves what 2 justices specifically wrote about private citizens. To understand why this case matters so much, you need to know exactly what Missouri created with this law. Missouri passed House Bill 85 in 2021, and this legislation is unlike any gun rights law that's ever existed before. The law specifically declares that federal firearms regulations exceed constitutional authority when they restrict manufacturing, ownership, or use of firearms within Missouri's borders. But this isn't just some symbolic resolution that politicians can wave around during campaign season. This law created actual enforceable penalties against state officials who cooperate with federal gun enforcement. The legislation emerged after years of growing frustration among Missouri lawmakers who believed federal agencies were systematically overstepping Second Amendment boundaries. Between 2008 and 2021, the ATF proposed or implemented over 15 major regulatory changes affecting firearms, bump stock bans, pistol brace regulations. The list kept growing, and Missouri decided enough was enough. Here's what the law specifically prohibits. No Missouri state or local officer can participate in enforcing federal gun laws that the state deems unconstitutional. They cannot provide personnel, they cannot provide facilities, they cannot provide equipment or any resources whatsoever to support federal enforcement actions. Think about what this means practically. If federal agents want to enforce certain gun regulations in Missouri, they have to do it entirely with federal resources. No help from local police, no assistance from state troopers, no cooperation from county sheriffs. The federal government is completely on its own. The law also extends protection to Missouri gun manufacturers and dealers, shielding them from federal regulations that exceed Second Amendment protections as Missouri defines them. The state's lawmakers intentionally designed this law to force a constitutional showdown, but the enforcement mechanism they chose is what makes this law truly revolutionary, and it's the part that has the federal government absolutely desperate to shut down. Here's where Missouri got creative, and it's the element that has federal authorities most worried. The law allows any private Missouri citizen to sue state officials who help enforce federal gun laws, not just file a complaint that goes into some bureaucratic black hole. Actually take them to court and win money damages. The minimum penalty is $50,000 per violation, and there's no cap on how high it can go. Let me put that in perspective with some real numbers. A typical local police department in Missouri might have 20 to 30 officers. If that department assists federal agents in enforcing what Missouri deems an unconstitutional gun law and a citizen successfully sues, the liability could reach $1 million to $1.5 million for a single incident. The enforcement mechanism operates on a bounty system similar to qui tam whistleblower lawsuits. Any citizen with knowledge of a violation can file suit, and if they win, they collect the penalty. The law also includes attorney's fees, meaning even if the citizen wins just $50,000, the government might owe hundreds of thousands more in legal costs. Missouri essentially privatized constitutional enforcement. This creates an impossible situation for law enforcement officers across the state. Consider being a sheriff in rural Missouri who's worked with federal agents for years on joint task forces. Now you have to carefully analyze every single federal request to determine if it involves firearms regulations that Missouri considers unconstitutional. Get it wrong, and you could personally owe $50,000 to whoever decides to sue you. That's exactly the point. Missouri wants federal gun enforcement to become so legally risky that state officials simply refuse to participate. The strategy is to make cooperation radioactive. Now, Missouri didn't invent this enforcement strategy out of nowhere. They copied it directly from Texas Senate Bill 8. That's the Texas law that banned abortions after a fetal heartbeat is detected, usually around 6 weeks. Instead of having state officials enforce the law, Texas allowed any private citizen to sue anyone who performs or aids an abortion. The Texas law went into effect in September 2021, and abortion providers immediately tried to challenge it in court. But they hit a wall because of how the enforcement was structured. Normally, when you want to stop a law, you sue the state officials who enforce it and ask a judge to block them. But with the Texas law, there were no state officials enforcing it. The enforcement came from private citizens. The Supreme Court heard the Texas case in December 2021 and issued a decision that shocked legal experts on both sides. The court said you cannot get a pre-enforcement injunction against the state because the state isn't enforcing the law. The only way to challenge it is to wait until someone actually sues you under the law, then defend yourself in that lawsuit and argue the law is unconstitutional. Missouri's lawyers studied that Texas decision carefully and realized they could use the exact same structure for Second Amendment rights. If it worked to protect abortion restrictions from court challenges, it should work to protect gun rights too. The federal government sued Missouri in March 2022, claiming the law was unconstitutional under the Supremacy Clause. Their argument was straightforward. Federal law trumps state law, and Missouri cannot simply nullify federal regulations it disagrees with. Judge Brian Wimes of the Western District of Missouri heard the case and issued a preliminary injunction blocking the entire law. His ruling was extensive, over 60 pages analyzing constitutional history and federalism principles. The judge found that Missouri was essentially attempting to nullify federal law, which the Constitution prohibits. But here's what's interesting about Judge Wimes's reasoning. He specifically addressed the private enforcement mechanism and rejected Missouri's comparison to the Texas abortion law. The judge said there was a crucial difference. The Texas law regulated private conduct between private parties, while Missouri's law attempted to regulate federal government operations. According to the judge, states have broader authority to regulate private behavior within their borders, but they cannot obstruct federal officials from enforcing federal law. The injunction prohibited Missouri and all its officers, agents, and employees from enforcing or implementing any part of the law. The judge also barred anyone acting in concert with state officials from enforcing it. Missouri immediately appealed to the 8th Circuit Court of Appeals, and that's when things got even more complicated. Justice Clarence Thomas was the only vote to grant Missouri's stay application. While he didn't write an opinion explaining why, his vote speaks volumes about his constitutional philosophy. Thomas has a long record of supporting both state sovereignty and Second Amendment rights. His dissent here likely stems from his view that states should have more power to resist federal overreach. He's previously stated that the 10th Amendment reserves significant authority to states, and that includes the power to refuse cooperation with federal programs states believe are unconstitutional. In a 2012 case involving immigration, Thomas wrote that states cannot be commandeered to enforce federal law. That principle applies directly to Missouri's situation. The timing of Thomas's vote is also significant because it came just months after he wrote the majority opinion in Bruin, one of the strongest Second Amendment victories in Supreme Court history. That case struck down New York's concealed carry restrictions and established that gun regulations must be consistent with historical tradition. If Thomas believes federal regulations violate Second Amendment history and tradition, it makes sense he'd support Missouri's attempt to resist those regulations. But Thomas standing alone on this vote reveals something important about the current court. Even the other conservative justices who voted with him in Bruin weren't ready to support Missouri here. That suggests they see a meaningful difference between striking down a state gun restriction and allowing a state to nullify federal enforcement. Now we get to the part that changes everything. Two justices issued a statement with the denial that completely reframes what this order actually means. Justice Neil Gorsuch wrote it, and Justice Samuel Alito joined him. This wasn't a dissent. They both voted to deny Missouri's stay application. But what they wrote alongside that vote is extraordinary. Gorsuch wrote that he agreed with denying the stay with one critical understanding. The district court's injunction only prohibits Missouri, its officers, agents, and employees from enforcing the law. That's it, nothing more. The injunction does not and cannot bind private parties who weren't before the court. Gorsuch specifically said that any injunction trying to bind private citizens would be inconsistent with the equitable powers of federal courts. He cited directly to the Whole Woman's Health case about the Texas abortion law. This is massive, because it means the enforcement mechanism Missouri created is still alive. Private citizens in Missouri can still sue state officials under the law. The state government can't enforce it because they're enjoined. But individual Missourians weren't parties to the lawsuit and aren't bound by the injunction. Think about what this means practically. If a Missouri police chief helps federal agents enforce a gun law the state considers unconstitutional, a private citizen could still file a $50,000 lawsuit against that police chief. The state attorney general can't bring that lawsuit because the state is enjoined, but private citizens aren't enjoined. Gorsuch and Alito just told them the courthouse doors remain open. This transforms the Supreme Court's denial from a defeat into something much more ambiguous. It's almost like they're winking at Missouri gun rights supporters and saying there's still a path forward here. Missouri citizens who want to enforce this law can still file lawsuits, and they have a roadmap from Gorsuch and Alito on how to do it. The key is that they must be acting independently, not in concert with the state government. Here's how this could work in practice. Let's say a Missouri citizen learns that their local sheriff's department assisted ATF agents in enforcing a federal regulation that Missouri's law declares unconstitutional. That citizen files a lawsuit in state court under the Second Amendment Preservation Act seeking $50,000 per officer involved. The sheriff's department will likely argue the federal injunction prohibits this lawsuit. But Gorsuch and Alito just suggested that argument fails because the injunction only binds the state, not private citizens. The federal government would then face a difficult choice. They could try to intervene in that state court lawsuit and argue the law is preempted by federal authority, but that puts them in the position of defending in potentially hundreds of individual state court cases across Missouri. Or they could ask the federal district court to expand the injunction to cover all private enforcement. This creates exactly the whack-a-mole problem the Texas abortion law created. You can't get one big injunction that stops everyone. You have to fight each lawsuit individually. For the federal government, that's a nightmare scenario because they lack the resources to defend in every county courthouse in Missouri. For Missouri gun rights supporters, it's exactly what they wanted. The case now returns to the 8th Circuit Court of Appeals for full briefing and argument on the merits. This won't be decided quickly. Appeals typically take 6 to 12 months from briefing to decision, sometimes longer for complex constitutional cases. The 8th Circuit is generally considered one of the more conservative federal appellate courts. It covers 7 states, including Missouri, and it has ruled in favor of Second Amendment claims more frequently than most circuits. Between 2008 and 2023, the 8th Circuit decided 12 major Second Amendment cases and ruled for the gun rights position in 9 of them. That's a 75% success rate compared to the national average of about 55% across all circuits. Missouri has strong arguments on appeal. They'll point out that the Supreme Court has repeatedly said states cannot be forced to enforce federal law. The anti-commandeering doctrine from cases like Prince and Murphy says exactly that. Missouri will argue their law doesn't violate federal law, it simply refuses to help enforce it. But the federal government has strong arguments too. They'll emphasize that Missouri went beyond refusing to help. They created penalties against state officials who do choose to cooperate. The law doesn't just protect state sovereignty. It punishes officials for working with federal authorities. The government will also argue that the private enforcement scheme is a transparent attempt to evade judicial review and should be rejected. This case is far from over. The Gorsuch-Alito statement has opened a door that the federal government thought was closed. Private citizens in Missouri may still have the power to enforce this law, and that changes everything about how this legal battle will unfold. The Eighth Circuit battle ahead will determine whether Missouri's strategy survives or falls, and depending on how that goes, this case could easily end up back at the Supreme Court for a full hearing on the merits. What we're watching is a fundamental clash between state sovereignty and federal supremacy, with the Second Amendment caught right in the middle, and the outcome will shape gun rights across this country for years to come. And that's it for today, folks. See you in the next video.